everyone, this is Anamika. I am a second year law student at Amity University, Patna. Currently, I am working as a legal intern at LEXIS and Company for the month of June and July. Today in this video, I am going to discuss essential religious practices test in the light of recent judgments given by our Indian judiciary. The concept of essential religious practices test was nowhere in the Constitution of India, but it has developed with the judiciary's over-enthusiasm. In spite of having a well-defined provision on freedom of religion provided under Article 25 of the Indian Constitution, which is subject to exceptions of public order, health and morality, but the judicial development of ERP has added a catena or a chain of ambiguity and subjectivity to the interpretation of religious practices. However, the ERP has developed with a different objective and with a view that it will differentiate between the religious activities and the secular activities and will stop the propagation of immoral and irrational activities in the name of religious practices. Recently, the Indian judiciary has also created various ambiguity in determining the criteria of determining essential religious practices test. In Indian judiciary, the ERP test was first coined in the Shirur Mutt case of 1954, where the Supreme Court in this case held that the term religion cover all the rituals and practices that are integral to a religion and took the responsibility upon itself that it will only determine that what are the criteria for passing the test of essential religious practices. In the case of Nikhil Soni versus Union of India, the Rajasthan High Court held Santra practice as it does not fall under the essential religious practices, but it left the ambiguity that on what criteria it held Santra practice unconstitutional. Furthermore, in the case of Gram Sabha village Battis Shirala versus Union of India, a particular section of society claimed before the Bombay High Court that capturing and worshipping live cobra during the Nag Panchami festival was an essential religious practices of their religion. However, the court in this case relied upon a historical book and rejected the contention. In a similar case, where a Muslim police officer challenged in the Kerala High Court that a regulation is stopping him from keeping beard, the court, rather than relying upon the religious validity of this part, the court rejected the plea simply by saying that the certain Muslim dignitaries does not keep beards. So, if the judiciary keeps on providing constitutional protection to those elements of religion which the court thinks is essential, will only lead to more and more chaos and conflict in the nation. So, if you guys have any queries regarding this video, you can comment below in the comment section, and For more legal updates, please like and subscribe the channel.